Are you aggrieved by the decision of the Controller General of Patents in India, or you are not satisfied with the findings of the Registrar of the Trademarks in India? If you wish to understand that what are the various provisions available to you to challenge such order or decisions of the intellectual property offices in India, then this video is for you. You are aware of the fact that earlier in India we have IPAB, Intellectual Property Appellate Board, which was exercising appellate powers over the decisions of the patent office or the trademark registry or the copyright registrar or any other intellectual property offices. However, after the abolishment of the IPAB, because of the enactment of Tribunal Reforms Act 2021, the appellate powers of the IPAB were transferred to the respective high courts in India. Subsequently, the Delhi High Court established an exclusive intellectual property division which will be adjudicating various intellectual property related matters under its jurisdiction. Every high court in India has its own rules, whereas in this video I will discuss about how the intellectual property division of the Delhi High Court can exercise its appellate powers over the decisions of the intellectual property offices. I will discuss which are the various intellectual property offices which will come under the purview of the intellectual property division of Delhi High Court, as well as we will have a brief idea on the various sections under which you can approach the IPD of the Delhi High Court to seek remedy against the orders or the decisions of the IP offices. Let us first discuss the various IPOs which come under the purview of the Delhi High Court. The first is Trademark Office, the Registrar of the Trademark, which is responsible for ensuring registration related activities or the opposition related activities in relation to a trademark. The second is the Copyright Office, which come under the Registrar of the Copyrights. The third is the Patents. It is equivalent to the utility patents in USA, and it comes under the Office of Controller General of Patents, Design and the Trademark. Fourth is the Design. In India, we say it as a industrial design registration, or in US, it is generally referred to as the design patents. But it also comes under the Office of the Controller General of Patent, Design and the Trademark. The fourth category of the IPO is geographical indication, which is headed by the registrar of the GI. The fifth category is the protection of the plants varieties and farmer rights authority. And finally, we have the office of the registrar of the semiconductor integrated circuits layout design. If you are aggrieved by the orders or the decisions of these offices, you can approach to the IPD of the Delhi High Court. So let us now move forward to understand under which sections you can approach the IPD of the Delhi High Court. If you look at this presentation, in all these four rectangles, you will find out a heading which starts with this C.A. then com.ipd hyphen tmcr pat or d. What does that mean? So under the IPD rules of Delhi High Court, the nomenclature is used as in this way. C.A. means civil appeal, com. means it's a commercial matter, IPD means intellectual property division, and then the office of the intellectual property, and then the corresponding office of the intellectual property right. For the trademarks, it is being indicated as TM. For the copyright, it is being indicated as CR. For patents, it's PAT, and for designs, it is DE. Let us now quickly go into the specific sections of the various intellectual property laws which has given the appellate powers to the Delhi High Court. First of all, if we look at the section 91 of the Trademarks Act 1999, we will get to know that almost blanket powers of appellate jurisdictions are given to the Delhi High Court. You can challenge any order or any decision of the registrar of the trademark office. The timeline to file the appeal is 3 months from the date of the receipt of that order or the decision which you wish to challenge before the IPD. So after Trademark Act, let us get into the section 117 of the Patents Act 1970, which has given the appellate powers to the Delhi High Court. The section 117A has two subsections. Under the subsection 2, it has listed various sections such as like section 15, 16, 17, 18, 19, 20. These are the sections under which the appeal against the order or the decision of the controller lies before the Delhi High Court. However, the subsection 1 of section 117A of the Patents Act also discloses that apart from the various sections listed in the subsection 2, no appeal will lie against the order or the decision of the controller in the Patent Act. So, in a nutshell, there are some orders or the decisions against which you have right to file the appeal to the Delhi High Court, whereas for other matters, the Indian Patent Act does not allow to file any appeal proceedings before the Delhi High Court. It is important to understand that for most of the important adjudication related issues before the Controller General of Patents, the appeal lies as per the subsection 2 of the section 117A of the Indian Patent Act. Whether the stage is at the prosecution of your patent application, whether it is at a opposition proceedings, revocation proceedings, you have a dispute over the assignment of rights in the patents, you have a dispute over the inventorship, you have a dispute over the mentioning of the name of an inventor in the patent application. All such key disputes, if adjudicated by the patent office, they are challengeable under the subsection 2 of 117A of the Indian Patent Act. So let us move to the third IPO, which is the Copyright Office. And under section 72, and if we refer very briefly to the section 72, again, we can file an appeal against any final order or any order of the registrar of the Copyright Office to the Delhi High Court. Let us quickly go through this section 36 of the Design Act 2000, which empowers the Delhi High Court to hear appeal against the orders of the Controller General of the Patent Design and Trademark Office. A brief look at the section 36 of the Design Act would disclose that appeal lies only from the specific acts of the or the orders or the decisions of the controller, rather than from every order or from every decision of the controller of the design. Specifically, if we look at the Design Act 2000, section 5, which is in relation to the registration of the designs, section 19, which is in relation to the cancellation of the registration of the design, then rectification proceedings, as well as the section 35, which is in relation to the refusal of registration of the design. So these are the few sections under which the appeal lies before the Delhi High Court against the decisions or the orders of the Controller General of the Patent, Design and Trademark, which is responsible for taking care of the design related matters in India. If we undergo through the section 31 of the GI Act 1999 and the section 42 of the Semiconductor Design Act, then we will get to know that we can challenge almost every order or decision of the respective office of the intellectual property, that is the GI or the semiconductor integrated circuits layout design. Now coming to the section 56 of the Plants Variety Act 2001, we have almost five categories against which we can file an appeal to the High Court. The five categories includes: first, the matter related to the registration of the variety of the plant. Second is matters related to the registration as an agent or a license of a variety. Then, if we have orders or the decisions in relation to the claim for benefit sharing, and revocation of the compulsory licenses or the modification of the compulsory licenses. And the fifth category of orders or decision is which relates to the payment of compensation made under this act. So only these orders or decisions are appealable before the Delhi High Court under the Plant Variety Protection Act. In addition to the appellate jurisdiction over the various IPOs, the IPD of the Delhi High Court is also empowered to entertain appeal under Section 62 of the IT Act 2000. In this section, if you are aggrieved by any order or decision of the appellate tribunal under the IT Act 2000, you can file your appeal before the IPD of the Delhi High Court. Lastly, the IPD of Delhi High Court is empowered to entertain appeal arising from the various commercial suits which are either disposed of or which are still prosecuted at the lower district courts. So the kind of appeal could be RFA, which is a regular first appeal. It is similar to any RFA in other civil jurisdiction. Then FAO, first appeal against the order. Which is some sort of, you can consider that if you received an injunction order under 39(1)(2) at the lower court, then the affected person can approach the IPD of the Delhi High Court and file at FAO. If you are at the execution proceedings, then the EFA, the execution first appeal, would be also entertained by the IPD of the Delhi High Court. I hope this presentation would have helped you to understand about the key requirements and the various sections under which you can file an appeal against the order or the decisions of the intellectual property offices in India. Should you have any specific question, you can comment below in this video, or you can write to us at info@nyaytantra.com, and you can also reach to us at 9910092805. Thank you so much for going through this video, and we will bring more such videos which would assist you to understand the IPR practice in the courts in India. Stay tuned to this channel. Until then, Jai Hind.